was looking for an absent judge. Yes, Mr.
My Lords, just two things. I'm not going to formally take you through Mr. O'Sullivan's judgment because I feel I've given you the submissions in relation to both the test, whether there was a satisfaction of the two requirements, and I've given you the four alternatives that I say, the three.
Well, you say, I mean, on the 40.8a point, you say, well, this was premature to discharge this judgment anyway.
Yes.
And it may well be perfectly proper to discharge it when you've got something to replace it with, but you don't do the vacillation that I put to you.
Yes. Yes, and that brings me to my second point. Lord Justice Popplewell posed a practical scenario to me and said, what would your reaction? I think I used the word pleased or delighted. I've been instructed to make clear to the courts that regardless of the outcome of our appeal on CPR 3.17, Motorola consents to a stay pursuant to 40.8a with liberty to apply to the parties and with the conditional amount to remain where it is until further order of the court.
So can I just have that clear? Regardless of the outcome of the 3.17 appeal, Motorola consents to a stay under 48A with the amount to stay in court until further order of the court.
Yes, with liberty to apply.
Yeah, okay.
That would be difficult, but I'm not quite sure how that works when you say regardless of the outcome of the appeal on 3.17.
Yeah.
If the appeal is allowed, is dismissed, so that judgment is gone. Well, are you making an application? There isn't an application made against you to which you'd be considered.
What I didn't want to say, my Lord, is that I was abandoning my appeal.
Yeah, I think what you mean is if you win the appeal and it was not appropriate because of 48A to discharge the judgment at this stage, you would be prepared to consent to a stay if they ask for one under 48A, or to submit to an order made by the court.
Yes.
On the same terms with liberty to apply in respect of the Jacobs order and everything.
Yes.
else.
Exactly.
Yeah, okay. I think we sort of understand. Have to see what Mr. Rubin's got to say about all that, Mr. Strange.
Thank you, my Lord.
Okay. Now, Mr. Rubin, we don't think we really need to hear you on the Calver appeal unless you have some remarkable and new and interesting things to tell us. But we are, as you will have gathered, very interested in hearing you on the second, on the O'Sullivan appeal.
Well, that's very helpful, my Lord. I'm actually just going to touch on one or two things in the Section 5 appeal, just to highlight them. Literally, hopefully, should be very short. Yes. But it had already been arranged before the developments over the last 2 days for Mr. Milner was going to argue the revocation point.
Okay.
Mr. Milner, KC. So in those circumstances, he will be arguing that.
Just before you get started, you kindly sent through some of the US court orders that you said existed, but I didn't get an order which I think you said was made following the February variation. I thought you told me there was an order made in May.
Yes, I did say that, and the reason I said that is that I picked up the paper. The date was in the American form reversed, so I was reading off the bottom, and it said May, but in fact that was not the month. So that was
one of the other orders that was one of the other orders you sent us.
Yeah, so it's that's the two. I was looking at the same two orders, but it was not dated. It was March.
So in relation to the judgment in its final so far as the multiple damages claim is concerned. It is so ordered at the end of the February narrative judgment. Thank you.
So the one or two points I wanted to make in relation to the Section 5 point are firstly that the meaning is clear, and 3 judges who've concentrated on this point have said so, and who've had it directly before them: Lord Hope, then a judge of the Outer House,
Lord Hope?
and
Hodge.
Sorry, Lord Hodge. Sorry, and then Lord Mr. Mrs. Justice Cockerell, and now, although in fairness, it was technically over to, but she concentrated very much on it, so it was pretty well on point. And then thirdly, Mr. Justice Calver. All have found it very straightforward. The cables which you've seen, I don't know whether you've read the cables, but I wanted to highlight some parts of them to you. I don't want to take you through material you've already read.
I've read them. They're in that book.
Yes.
I'm sure I've read them. So
well, I think, my lord, you would find them useful to do so. They're in tab 25 of bundle 2.
I don't have a bundle 2.
Page. Sorry, yes. Sorry. They're in low. The low.
So this is in the Calver supplemental bundle, is it?
This is the Calver authorities bundle at tab 26. Oh, sorry, page. Your pagination is on
Page 732.
Page 732. And the passage I want to show your lordships is, this is an exchange, my lord, between the US Embassy and the British Embassy. So it starts at page 735. So the Embassy of the United States in London to the British government in the run-up to the act, the bill going before Parliament. And one sees in the middle of that page the rubric Embassy of the United States in London. Below that, the Ambassador of the United States presents his compliments. The subject matter is the introduction of the Protection of Trading Interest Bills, gives us concern on several different levels. And then if you turn to page 737 towards the top of the page under enforceability of judgments, it says, we understand why the United Kingdom may not wish to facilitate the enforcement of non-compensatory portions of the United States multiple damages awards, but we read clause 5 as having a broader effect. It would preclude an action to enforce any sum payable under such a judgment. Thus, even the compensatory portion of the award would not be enforced. And then going down, this is, anyway, I'll just take it shortly. This is responded to by Her Majesty's Government through the Embassy in Washington at page 740 under the rubric British Embassy in Washington to the United States Government. Her Britannic Majesty's Embassy presents their compliments and is responding to these concerns. And if one looks over at page 741, just over halfway down, clause 5 clarifies a question of UK law by declaring that the multiple damages judgments in other states which are regarded by Her Majesty's Government as penal are not enforceable by the UK courts, just as other judgments of a penal character. Furthermore, both this provision and the discretionary power under clause 5.4 reflect the principle whereas sovereign states do not accept the obligations to enforce economic policies of other sovereign states. The US Ambassador's note points out that under clause 5 even the compensatory portion of the award would not be enforced. And that provision is not limited in its applications to circumstances in which Her Majesty's Government believe the foreign court does not have jurisdiction. Bearing in mind the objectionable features that appear to Her Majesty's Government to arise from the impact of private treble damages actions on international trade, as well as the general justification for proposing there should be a separate provision enabling UK courts to be used to enforce a part of such judgments. And then over the page,
there we are.
Her Majesty.
They agree with you.
Sorry?
They agree with you.
They agree. Now,
we agree with
But
you.
you say this is all inadmissible because the language is clear.
Yeah. Well, yes. And I'm going to accept that this is an explanatory. This is material which is extraneous and which you'd only look at set context, and in a way it's saying what we say is clear, so it's only reinforcing, in a sense, doing the
thing
job.
I find most remarkable, Mr. Rubin, is that courts historically have made such a meal of this statute. I mean, it looks like a statute. I won't say any more than that.
Well, in greatest respect, my lord, I don't mean to be any disrespect to the two judges who found it unconvincing, but most judges didn't make a meal of it. I mean, most judges made long discussions.
They're super lengthy judgments.
Yes, that's a fact.
I hope we'll do better than that.
The second point I wanted to make is about this concept that my friends rely on. They say that Mrs. Justice Cockerell, as she then was, introduced the concept of a cause of action determinative into this debate, and she had no business doing so. Well, I just want to point out to you that in Lewis and Eliades, Lord Justice Potter twice uses the phrase cause of action, most notably at paragraph 41, where in that, which is the very paragraph in which he could be said to be the heart of, this is at page, it starts at page 206, and the page I'm looking at is page 216. When he's looking at this very point that we're looking at, he starts by saying, so far as Mr. Warwick's, this is at paragraph 41, page 2. So far as Mr. Warwick's first point is concerned, I accept, and indeed is not an issue between the parties, that the 1980 Act makes clear its hostility towards awards of multiple damages by barring enforcement in the United Kingdom of part of such awards, including the basic compensatory award, to which a multiple element has been applied and superadded. Then he goes on, the wording of this definition in section 5.3 makes that clear. However, I do not consider the wording provides the answer to the question whether when the judgment is part only a judgment for multiple damages as defined in section 5.3, but also comprises a judgment for a simple compensatory sum in respect of a separate cause of action. So he introduces the whole idea of looking at these judgments, judgments where there are several different heads of damage.
I mean, I know, but I think we're about to say the same thing. A judgment is not a cause of action.
No.
Nor indeed does the principle for which you contend depend on multiple damages and purely compensatory damages being on different causes of action. If you had a claim under a statute which enabled multiple damages to be granted, but in respect of the first part of the period, the damages were said to be X on a purely compensatory basis, but it was then said from a particular date the breaches were then willful and malicious because they'd been told about them by the other side, and from that period on the damages are going to attract treble damages. You would still only have a judgment for multiple damages in relation to the second period with its compensatory element and its punitive element, and you would, on the same cause of action, have a simple claim for compensatory damages.
No,
and you wouldn't say, I don't think, would you? Well, because they're all on the same cause of action, you can't distinguish between the different aspects of the judgment.
That would be another case. I'm certainly not going to suggest that's a way into this.
Well, the point is, Mr. Rubin, the word judgment is used as a very general word because it is talking about the 250 jurisdictions in the world that are not England and Wales, which may come in and be relevant to it. And so it's a word that is intended to encompass quite a lot and maybe different situations in different ways. So it would be quite unhelpful to start giving it an English meaning, which then might be falsified by a judgment in another country with a completely different regime. So, I mean, for my part, I don't even find very helpful the definition in the 1933 Act. I'm not sure that's directly transferable.
My lord, I was going to say that's another whole different thing. And this is a specific definition of judgments for multiple damages. It's specific to this Act. But the point I was really making is it's not fair to say that Ms. Justice Cockrell introduced this. It comes from what she considered to be, if not binding on her directly, it certainly was as regards aspects that are extraneous causes of action. So she was merely doing that.
It's not irrelevant, but it's not the fundamental test.
No, that's true. That's true. The third point that I wanted to make is just I don't know whether you are on the issue of the ancillary nature, ancillary orders that my friend addressed towards the end of his submissions.
He made a distinction between interest and cost.
Yes, he made a distinction in interest and costs. The one in relation to costs, you should bear in mind that the costs in this instant case, as my Lord Justice Popplewell, I think, was just referring to in a sense, those costs were were only allowed, as you saw from the order of the court, to be one of the bases for giving costs. One of the bases was the Act itself, the DTSA, and we can't distinguish those costs between what costs were attributable to that cause of action or the other cause of action. And so, similarly, Lord Hodge in Service Temp, he made clear that he wasn't prepared to enforce the costs from America in that case either. My friends have challenged that in their skeleton, but if you look at the report, you'll see in the first paragraph, he makes it absolutely clear that he's dealing with the costs from the United States. My lords, my friends have hardly developed. They just touched on the word human rights, but really didn't develop anything.
Sorry, just before you leave interest, the 51.1 million in prejudgment interest does not include any interest on the punitive damages element. It's only calculated on the basis of the compensatory element of both the copyright claim and the DTSA claim.
But this court and the court below is incapable of distinguishing. There's no calculation to this court.
Forgive me for a moment.
Sorry?
Forgive me for a moment. It would it not, be perfectly possible to identify, even though no one has in fact yet done it, which part of that was attributable to the copyright and which part was attributable to the DTSA claim. But that doesn't matter from our point of view, because if you're right on your section 5.3 point, it's only the copyright element, if identifiable, which could be recoverable, but that's going to go because the principal sum is going to be reduced. So that can't be enforced in that form anyway.
No, my lord, that's absolutely.
Is that the right way of looking at it?
That is certainly a less contentious way of looking at it than saying they haven't produced any form of evidence from which the court can make such a determination. But I can see your lordship would say, well, that maybe something could be done later. But
so the point is, if you go back to America and you get a judgment for 14 million, and you ask for interest on that judgment, and it's awarded regularly in the normal way, and you then seek to enforce it, because there's a final application. I mean, assuming we go the way we were discussing with Mr. Strange, and we don't say we will, but we might, then you would be able to come back and say, no, I want that. They would be able to say, I want that interest, which is directly applicable to the copyright damages that have been awarded on appeal.
Of course.
Yeah, I mean, that's obvious, really.
Very, my lords. So that moving on from the issue of construction.
But sorry, were we told that the interest order has not been set aside at all? No.
I think, my lord, that was the costs and the
costs.
attorney fees.
The costs not been set aside. Has the interest order been set aside?
Our case is that that's one of the issues on this finality point that is yet to be resolved, is that we say once the judgment was remanded to the lower court, it opened up issues of interest and costs. Our opponent's position, I thought, was that it didn't interfere with costs, but I think they accepted it interferes with interest.
Is that right?
Yeah, that's right, my lord, yes.
I'm going to write it's common ground that the prejudgment interest order in relation to the copyright claim has been remanded. Yes, you're both nodding.
Yeah, well, I'm content with those words, but I think the effect is that it's remanded, and if my friends...
Yes, and he's right, because the remand directions aren't particularly clear, and there's argument about the copyright.
But you accept
Yeah.
that falls to be reduced to the extent that the copyright damages.
Yes, yes. I could take a hypothetical point that doesn't seem to have been a remand of it, but I don't think that will get me anywhere.
All right, thank you.
My Lord, we had prepared, but I'm reluctant to involve the court's time, particularly given the indication in a response to the A1P1 submission of the human rights.
We've dealt with it in the skeleton.
Yes, we've dealt with the skeleton. On the amendment application,
It doesn't arise if you're right on section 5.3.
no, it doesn't say. But all I can say about it is that there is a point at which you cannot, at this sort of litigation, highly complex litigation with well-resourced and informed parties, for them to adopt a position not only before trial, in their pleadings before trial and at trial, even though we had written to them saying, are you sure this is what you mean? And then go through the trial, not ask for this, and then to come and ask for an amendment after trial.
You may well be right, but the area of late amendment is quite developing and quite contentious, and as a subject of a recent judgment of mine and Lord Justice Lewis, and it's not free from difficulty, and you would be pushing at a closed door if you were asking us to comment upon a late amendment application that wasn't relevant.
No, I understand that, my Lord. I was actually going towards the Henderson point,
right,
which is that although I can't point to any particular prejudice, and which is often the way a Henderson case is put, there comes a point up with which one cannot put. I mean, there is a limit at this sort of litigation where, as I say, fully resourced, legally competent persons take positions in a case and have it tried out where the court cannot tolerate, in my respectful submission, a change of position, which I know you're not going to rule on it, but what I would say is that if there were an amendment allowed and if it had to happen, it would be a point we would want to defend the next round of litigation by pleading as a defence to the claim. That's all I say on that point, because it is not a dead point in my respectful submission, even though I can't point to any particular prejudice.
But if the amendment application is dismissed on the basis that the claim cannot succeed because of the proper interpretation of section 5, that's it.
Yes, it is.
There won't be another round at which you've got to deploy a...
I accept that, and I can see where it's going, but in the direction of the court's mind on this. But all I'm just saying is that the application was taking advantage of a misunderstanding by the Lord Justice who gave leave, and it shouldn't have been made, and it has taken up a lot of time in dealing with it, and on paper and in research, and in my respectful submission, I just wanted to make the point that it was an abuse of the process. That's the matter which I'll now hand over, if I may, to Mr. Milner to deal with the revocation.
Yes, Mr. Milner. How long do you expect to be? It's not intended to be a discouraging start.
I think around an hour, possibly, maybe less, actually.
I mean, that's a remarkably novel use of a lectern. And I would like to say that if I were using it, I would have to cut it in half and do the reverse process.
Well, I accept it. It looks a little awkward. I like a flat surface, but anyway,
And also,
I'll do my best. If it collapses midway, I apologise.
If it works, do it.
My Lords, I'm going to proceed on the basis that what Motorola is now submitting is that the judge was wrong in that he should have ordered that the judgment of Mrs Justice Cockrell should be stayed under CPR 40.8a until such time as a new judgment was handed down in the United States.
Yes.
And that at that point it will be revoked, presumably also under 40.8a, and a new judgment would be issued. That's what I understood my learned friend to be accepting, was at least a...
Shall we say under encouragement from the court?
But that was not the entirety of his case. He did say that what I call his bad luck submission, that there were various things you should have done at the time, and as a result of that, 3.17 is justified.
Yes, well, I'm going to deal with that as well, but I'm going to, if I may, I'll focus on the fallback submission, which is that's what the judge should have done. That, of course, was not his position below. Below, his position was what my Lord Justice Popplewell has set out, which is that they should be free to enforce for the 136 million. Now, that was a position that made and still makes no sense at all in my submission. It would make a nonsense of the proceedings before Mr Justice Jacobs, which took place entirely on the basis that if the US judgment was set aside, it would then not be enforced. But that was the position that Motorola took, and that's why we made, on an urgent basis, an application for revocation in July 2024, as soon as the US judgment was handed down, and Motorola still stuck to the position they were now free to enforce, regardless of the setting aside of the judgment in the US. At that time, of course, 18 months ago, any new judgment was a long way off. We still don't know when any new judgment will be handed down. My learned friend said it was...
Everything's briefed and it's up to the judge, right?
Correct, well, yes.
Well, that presumably they have limits as to how long judges take to hand down judgments in America, even as we do.
Well, I don't know if there are strict limits. There have been delays in this case, and I do know that there were other issues the judge was dealing with as well as this issue, so it may be some time, but we simply don't know.
It's bound to happen.
So all I'm saying is that the statement that it's imminent was merely speculation and can't be any more than that.
He said very imminent.
Well, exactly. This is just in our submission, no basis. But anyway, I'll address that new case. Going straight to where we got to this morning and the debate about CPR 40.8a. In our submission, my lords, there are a whole series of reasons why that new case should not succeed, quite apart from the fact that we were only given any notice of it at 9 AM this morning.
Well, that's not quite true. I mean, the 40.8a, I think, comes at 9 o'clock this morning, but the last paragraph 41 or whatever it is of their skeleton gives you a bit of a clue.
May I just turn that up?
I mean, it's what he referred to. But I agree, it's not 40.8.
Yes.
Anyway, yeah. But I mean, just so you know where the court is on this, you may well be right, and you may have lots of arguments on costs and everything else. But if there is, if this is the right power and 3.17 is the wrong power, we're not going to set the law in a completely wrong direction just because it was raised at 9 o'clock.
No, well, that's why I anticipated that, and that's why I say, quite apart from that, there are a number of reasons why it's wrong or at least irrelevant. Can I just say this by way of overview? We respectfully submit that the position is extremely straightforward. The question, of course, is what should happen where an English judgment is obtained on the basis of a foreign judgment that is set aside on appeal. Now, in our submission, the normal response, quite obviously, should be that the English judgment should be set aside. I don't need to go so far as to say the invariable response, but at least the normal response should be to set aside the English judgment. And that's, in short, because there should be no difference in principle between that case, where there's a foreign judgment being enforced in England, and a purely domestic case, where a domestic judgment is overturned on appeal. In both cases, a higher court has decided that the claimant did not have the rights that the judgment is based on. And it follows that a judgment giving effect to those rights should not have been entered and should be treated as a nullity and should not continue to exist. And just one could take it a stage further than that and make this point, that the appellate judgment in the United States is itself entitled to recognition in this jurisdiction. That means that a party in our position is entitled to rely on that judgment in English proceedings. Now, the effect of the judgment is to negate the rights that arose from the earlier first instance judgment.
Is it right to say it's a complete nullity? Because what's happened is the judgment has been overruled on certain specific bases and sent back for reassessment of the damages on the basis of the new judgment, which means it's not that there's nothing against you. There is something that is in the process of being, it's like having a judgment for damages to be assessed. There's a judgment for damages to be assessed in America. Previously there was a judgment for liquidated damages. Now we have to wait and see what liquidated damages are. But I mean, although it could be nil, it's most unlikely to be nil. It's even, you say, between 1.3 and 1.5 million.
I completely accept that, my lord, but yes, is the answer to the question. It is as if it were a nullity for this reason, that in order to be capable of recognition and enforcement in this jurisdiction, the judgment has to be for a definite sum of money. And that's a binary question. They either have a judgment for a definite sum of money, in which case they can enforce it via an English judgment, or they don't, in which case they're entitled to nothing at all.
You can't have it that we have to recognise the Court of Appeal judgment, which is not for a recognised sum of money, and then say that the judgment has to be for a recognised sum of money to be recognised.
With respect, I'm trying to distinguish between recognition and enforcement, and in order to be entitled to an English judgment, in other words, to enforce the US judgment, that has to be for a definite sum of money.
Right, so we should recognise the Court of Appeal judgment in some slightly less serious way.
Exactly.
How?
Would you say that's the same for an English judgment? So if you had an appeal by a claimant which was successful because the claimant was contending that the amount of the judgment should be increased, and the Court of Appeal here said we'll set aside the order for judgment for X because it's got to go back to be reconsidered, to be increased. The only thing that could happen is that the judgment for X would be set aside, surely in those circumstances. If anything was to be done with that judgment, the court would say, well, stay of execution, or in that case, allow execution, but they're not going to get rid of it, are they?
My lord, no, but that's... With the
domestic on your basis, why isn't it a nullity once it's been set aside?
Because... Well, in the case of an English judgment, there is no requirement that a judgment has to be for a definite sum in order for it to be capable of enforcement. So
it's incredibly dangerous to talk about things in these very black and white terms, because we see from my lord's example there, and many other examples we've been talking about, that there is a very large range of different circumstances. And we, in this court, have, because cases like this do not get to this court very often, have to be jolly careful to make sure we cater for every eventuality and don't lay down principles which could be misapplied, because we have seen in the argument here an attempts to, and I don't want to be rude in my language, but attempts to, squeeze wording into different situations, which is jolly unhelpful.
Well, yes.
So, I mean, I'm not sure nullity helps as a sort of, I mean, it's been overturned on a particular basis on the facts of this case.
Yes. Well, I'm simply making the point, my lord, that as a general proposition, and I'm not asking the court to endorse it as a universal rule, but where a foreign judgment has been set aside on appeal, the natural instinctive reaction of any lawyer, I would suggest, is that an English judgment which is based on that judgment should no longer subsist. But I accept that's not going to be an invariable rule. Well, can I turn to the CPR 40.8a question? I have 5 points to make in relation relation to that. Can I just say, first of all, I have no difficulty with the proposition that's been articulated by the court that CPR 3.17 is in principle directed towards interim orders, and CPR 40.8a, by contrast, is directed at final orders. That plainly reflects the architecture of the CPR, where CPR 3 is concerned with case management and CPR 40 is concerned with judgment. So I have no difficulty with that distinction, but it's not one which is of any relevance or makes any difference in terms of the analysis or the outcome in this case. Can I make therefore the 5 points on 40.8a?
Is that not the 6th point?
That wasn't your first point.
That wasn't my first point.
No,
That was an overarching.
it's quite an important preamble.
I can renumber them with happily.
No, don't worry.
So I don't dispute that 40.8a covers broadly similar territory to 3.1, but in relation to final as opposed to interim orders.
So, I mean, that means you don't dispute that all other things, all your other 5 points being equal, it would have been appropriate for the court below to have had its attention drawn to 40.8a and been asked to make an order under it.
Correct. I would accept that we could have, in the alternative, have made our application under 40.8a. My submission will be, for the reasons I'm about to explain, that would have made absolutely no difference to the outcome in terms of setting aside. But on any view, it would have made no difference in terms of what we're really concerned about in this case, which is the destiny of the security that is held in court. My Lord, the first point on 40.8a is that it is, with respect, doubtful whether there is in fact jurisdiction to set aside a judgment under that provision at all. And the reason I say that is the discussion in the Raja case, which was referred to earlier. And a copy of that has been sent to the court. I hope the Lordships have it.
Indeed.
I'll just take you briefly to that. I mean, the facts of the case so far as...
It's entirely my fault.
Oh, do we
Does
have...
anybody have a paper
Yes,
copy?
indeed.
Thank you. Thank you.
So, the facts of the case were that the claimants had been unsuccessful at trial and had been ordered to pay costs to the defendants. But the defendants had then breached various consequential orders, and so the claimants applied to stay the costs orders until those consequential orders had been complied with under 40.8a. And we can pick it up at page 13. Paragraph 53 refers to the fact that claimants had applied to stay the costs order. And then paragraph 56.
So where does it say that?
Paragraph 53 says, by application notice, the claimant applied for a permanent stay.
Paragraph 53, page 13.
Page 13, Lord.
Yeah.
So that's the application. And then paragraph 56 says, counsel put the application on the basis of 40.8a, which it sets out. And then paragraph 58 said there's no authority on 40.8a, and then...
That's not completely true, though, is it?
Well...
I mean, he's not to be criticised. This is extempore, isn't it?
Well, I mean, I don't know if it is...
It's reserved for 10 days.
Reserved for 10 days, yeah. But it's one litigant in person. Yeah.
So, anyway, there was no authority he was referred to, which was helpful. He then notes in 59 that it's an application for a permanent stay. And he says that in 59, a few lines down, although the application is for a stay of the orders, the effect of granting a permanent stay would in substance be much the same as an order setting aside the orders for cost. Of course, there can be an appeal, but that's not the jurisdiction I'm asked to exercise. There's no ground for an appeal. And then, in short, he says that the test is the same. Well, he notes that CPR 3.17 gives the court power to vary or revoke an earlier order. That wouldn't apply because they couldn't meet the conditions for 3.17. And so there shouldn't be a permanent stay either. The point is, my lord, there's no grounds for a permanent stay in that case, or indeed at all, because it is functionally the same as setting aside, and I think that's not controversial. I would submit if there's no power to grant a permanent stay because it's equivalent to setting aside, then by the same token there is no power to set the order aside under CPR 40.8a. But my lord, it doesn't matter because, and this is where this really goes, is that even if one assumes there is jurisdiction to set aside or permanently stay, the test is and should be in essence the same as under CPR 3.17. In both situations, one has to give effect to the principle of finality and weigh that heavily in the balance, and then ask oneself, well, are the new circumstances that have arisen sufficient to displace the principle of finality in relation to this judgment? And there's no rational reason why that should be any different, whether one's talking about CPR 40.8a or CPR 3.17.
Well, except 3.17 is in fact about case management.
Yes, well, absolutely.
And this 40.8a is a general provision about change of circumstances. So cases like Unicredit, which were argued entirely on the basis of there being no power in the CPR to do what had to be done in relation to a final order except 3.17, seen as a lacuna, are argued on a false premise.
Well, yes, absolutely, but surely the argument against using 3.17 again in relation to final orders is the principle of finality. That's
well. I mean, of course, you're pushing at an open door if you're saying the principle of finality in relation to a final judgment is the same, whichever procedural application you're making.
But we're not talking about the same concept of finality. In relation to 3.17, which is a case management power, then you're looking at the finality of those sets of proceedings and it being inappropriate to use a case management power where the proceedings have got to a stage where you're no longer in a case management situation. Finality is, as it were, the antithesis of interlocutory case management. If you're looking at 40.8a, it may arise in lots of different circumstances, but in the particular circumstances we're looking at, the finality of an English judgment giving effect to a foreign judgment which is subject to appeal is a slightly more slippery context. In one sense, it's sufficiently final at first instance to justify enforcement pending an appeal, but it's not final in the sense that it should remain in its full English form if in the foreign proceedings it is finally determined to be unjustified. So I'm not sure we're talking about finality in the same sense.
Well, I think we are talking about finality in the same sense, in that it is the principle that is the latter sense in which your lordship was using it. It is the principle that once an order has been made finally disposing of a case, then the principle of finality in this sense means that it should not be disturbed except in exceptional circumstances. That's the point. Now, as the judge rightly said, I mean that is the reason why.
Exceptional circumstances, of course, is an ill-defined let-out, but in 3.17, exceptional circumstances are regarded as very, very narrowly confined and arguably, although this may not be right, change of circumstances which are entirely foreseeable don't get you in that. If you're talking about setting aside a judgment which is subject to appeal, you're not talking about exceptional circumstances in the same sense at all, are you?
Well, no, man. I mean, I respectfully agree with that, but that's a point. That's not a point against our position. I mean, let me perhaps take a step back. The application up until today, this has always been argued through the lens of 3.17. 3.17 has been said to be very restrictive in relation to final orders because of the requirement or the importance of finality. Now, as to that, my argument is the judge correctly held that in this context, where a foreign judgment has been set aside on appeal, the finality has a relatively little role to play because the first instance judgment, which is subject to appeal, it is of course sufficiently final to be enforced, but at that time it is, as it were, pregnant with the possibility of its own nullification on appeal. And so everybody knows that it is liable to be set aside. And so the principle of finality, as the judge was correct to say, has no real, or certainly not great importance in that context, as it would in a normal piece of domestic litigation that's been finally decided. Now, if we shift from 3.17 to 40.8a, that widens the door to making orders that vary or set aside the judgment. I mean, in my submission, actually the test should be the same because finality is very important, but in this type of situation, that is overridden because finality is not a consideration that should have any decisive weight in this circumstance.
But it also widens the door to the possibility of a temporary stay pending the final outcome.
Yes, absolutely.
Of the foreign litigation. It's that possibility, I think, which you're now addressing.
Absolutely, my lord. And whether one's talking about an interim order, in which case the court can vary it under 3.17, it can set it aside under 3.17, it can impose a stay under CPR 3.1F, I think it is. It can attach conditions to an order. So it can do all of those things in relation to an order under CPR 3, albeit there's a restrictive approach in relation to final orders. It can do the same things under CPR 40.8. There is no fundamental difference between the two provisions. It's just that CPR 40.8a, in terms of the architecture of the CPR, is aimed at final orders in a way that CPR 3.1 isn't. But the analysis that the court goes through is not going to be material.
But it may or may not be. I mean, the problem is 40.8a is a quite different provision, which is aimed at a specific situation where there's been a change of circumstances. So if we look at 40.8a, it says, without prejudice to 83.7, which is about stays, a party against whom a judgment has been given or an order made may apply to the court for a stay of execution or other relief on the grounds of matters which have occurred since the date of the judgment or order. So it's a completely, and the court may by order, again, grant such relief and on such terms as it thinks just. So it's a very general provision which is quite different from 3.17a and may or may not be invoked in situations where 3.17a can't and vice versa.
Well, in terms of jurisdiction, Rod, I would that the suite of powers that the court has under CPR 3, at least in relation to interim orders, is as broader as in relation to 40.8a. But I don't need to argue against myself. I mean, 40.8a widens the door to interfering with a final order in a way that argue, but at least 3.17 doesn't. So I'm quite content with your Lordship's analysis up to this point. And I have no difficulty with the idea that 40.A allows the court, does give the court jurisdiction to either set aside or stay or make such other order as it thinks appropriate. And I have no difficulty with any of that. I would submit as a matter of logic that the analysis should give weight to the principle of finality to a similar extent as under 3.17, but I don't need to go that far.
Well, you're only on your first point, and that is that it was doubtful whether there's in fact jurisdiction to set aside under 40.8A because of budget.
Well, that was my first point. The second point was that if there is...
That you just apply the same test.
The same test. My third point, my Lord, is that the fact that the jurisdiction might be exercised under 40.8A rather than 3.17 is an almost entirely arid point. And that is because there's very little practical difference between setting aside and a temporary stay followed by revocation. There is the point, which is not an irrelevant point that my Lord Justice Popplewell put to my learned friend, that having a judgment against one's name, potentially for a substantial period of time, is inherently prejudicial. And that may be a difference between the two situations. But otherwise, there is no substantial difference between having a judgment that is stayed and having one that's been set aside.
Well, again, I mean, that may be the case, and it may not. There may be countless possible reasons why you would want to apply to get rid of the judgment at different stages, or not. But I mean, it's not possible to say this is the only difference.
No, I'm talking about this case now. I should have made that clear. But if this court was to say that the judge should have applied 40.8A rather than 3.17 and granted a temporary stay, so far as that goes, it's a matter of almost complete indifference to us.
Well, but the problem you've got with it may be indifferent to you, but it's not indifferent to me, because it appears that a number of cases have been determined on a false basis, that there was no power to set aside a final order on the ground of a change of circumstance. And that, I mean, not only cases with quite distinguished courts, starting with Rout, that appears to have been on a false basis because there was such a power in the RSC as well. And so it's all very well to say it's arid. It's not really arid, because it might be, I'm not saying it is, that those decisions are wrong, and that 3.17 is to be construed as limited to case management and interlocutory orders, in which case 40.8A is actually more limited in some ways, because it's only got one ground on it, whereas 3.17A is at large. So, I mean, I think the point is actually quite important.
My Lord, I do see that. I'm obviously not here to re-argue the earlier cases. I mean, this is a case where we're relying on circumstances subsequent to judgment. So, to that extent...
I mean, we could say one of two things. We could say, well, one of three things. We could say that you're right, and these two things are entirely equal and opposite, and it doesn't really matter. We could say that the judge did not have power under 3.17, did not have power under 3.17 because it was, which would be groundbreaking because it was about case management, but did have power under 40.8A. Or we could say that he had power under both. And each of those has quite different ramifications for the way you treat what is happening in this case.
Well, in my speech, it doesn't have any ramifications for the way in which one analyses this case and decides it. Or probably any case in which the applicant is relying on post-judgment change of circumstances. I could quite accept your Lordship's point that if you can't rely on 40.8a because there hasn't been a post-judgment change of circumstances, then CPR 3.17 would then be the only possibility, and there would then be an issue as to whether that could be relied on in relation to a final order, as has hitherto been assumed, or not. But I mean, that is no doubt an important issue, but it's not an issue that arises in this case, in my submission. Now, well, I'm making the point that so far as this case is concerned, and I would say many cases, though I quite accept my Lord's point that not necessarily every case this will apply to. It's an arid point because there's no difference in substance between a stay judgment and which is inevitably going to be revoked when the US court hands down its judgment, and one that's revoked now. And in particular, this is the critical point, that there is no difference in terms of what should happen to the security. The security was ordered and paid not just because there was a judgment in existence, but because there was a judgment that otherwise could have been enforced. In other words, the security was the price of preventing enforcement of the judgment. Now, we are arguing about different forms of relief that could be granted, and essentially the menu is narrowed to 3 options: setting aside, stay, and the halfway house of an interim stay followed by setting aside. But under all of those options, the one thing that is clear is that this judgment can and should never be enforced. Now, maybe there's scope for argument about what should happen to the security in those circumstances, and I'm going to come to that. We say that it should be repaid, but what should happen to the security should not be dependent on which of those options the court selects. And equally, which option the court selects should not be driven by the existence of the security or not. They're not rationally connected, because the basis for the security is that there's otherwise a judgment that could be enforced, and the quid pro quo is that the claimant gets security. Once it's clear that the judgment's not going to be enforced, whether because it's been stayed or revoked, or stayed and then revoked, then there is, well, we say there's no justification for the security remaining in place, but in any event, there's no rational connection between the selection, the choice between those options, and whether the security should come back. I mean, the court could, for example, set aside the judgment, but on terms that the security remain in court. That would be the opposite of what's being argued for by Motorola. They say it should be stayed, sorry, it's not the opposite of it, but the court has my point, that there are 2 separate questions, in short. What should happen to the judgment? Should it be revoked, stayed, or a combination of the 2? And what should happen to the security? And those are not connected.
I don't want to argue about it, but it seems to me to say there are 2 separate questions in the face of 40.8a, which precisely says the court may by order grant such relief, i.e. stay of execution or other relief, on such terms as it thinks just, connects the 2. I mean, the whole point is here, the purpose of 48a is to allow, where there's been a change of circumstance, and it's not just to allow the normal ramifications of a final judgment to take place, the court has a complete discretion. That's what 40.8a tells you, or seems to tell you. So to say they're not connected, I mean, you know, Mr. Strange's view about this case is it's all about the 20 million that sits in court. But
Well, he's right about that, but right. Where he's wrong is to say that, to assume that if the judgment is set aside, the security falls away, and if it's not set aside, the security stays where it is.
no,
That isn't
indeed,
right.
but the 2 are not I mean, to say they're completely freestanding points that have to be dealt with in watertight compartments doesn't seem very helpful.
Well, with respect, I struggle to see the why the choice to stay as opposed to revoke should determine or even influence the decision as to what should happen to the security.
Well, the justice of the case is that however the 20 million got there, it should, for the time being, stay there as security for what will be, or may well be, a judgment for an amount up to that amount. That was not something which the judge in this case thought was open to him. He thought he was only able to deal with the 31.7 application because that was all that was made, and could only deal with it on the basis that he either had to grant a permanent stay, which was the same as setting aside, or set aside. Whereas if he'd been told that the application was also being made, where he should have been being made under 40.8a, and he had the power to do whatever he thought was just in the circumstances, then he could have, you may say he wouldn't have, but he could have considered granting a temporary stay and making the 20 million stay in court until the outcome of the American proceedings was known.
Absolutely. Well, that takes me neatly to what's going to be my next point, which is, with respect, the judge did consider that option and rejected it, and I'll show you that. But if the justice of the situation was that the security should stay in court to await the outcome, then that could be achieved whether or not the judgment was set aside or revoked. That's my point. So the real argument, where this is all going, is that the real debate is not whether the judgment should be revoked or set aside or stayed, which all amount to much the same thing. The real argument is what should happen to the security, and that is a question that arises independently of whether the judgment is set aside, stayed, or revoked. And that's where I'm...
Except there's no issue as to the security before us. Because if you look at the notice of appeal against the order that Mr Sullivan made, it simply says he shouldn't have set it aside under 3.17.
Well, if your lordships were to uphold the appeal to the extent of deleting the words 3.17, or even deleting the words the order is set aside, then so be it. That doesn't touch the fact that he's ordered the security to be returned.
Well, we can't touch this. We could by consent, but we can't touch the security on this appeal at the moment. Obviously, we can talk about it, we say what we think about it, but eventually...
Well, my lord,
because his order was that the security should be returned,
yes,
and it's only still there pending the appeal, as it were,
Yes.
rather than
yes.
No, you're right.
Well, can I make my fourth point, which is that the judge was aware that he had a discretion to exercise in this very respect. If we go in the judgment in core bundle page 84.
Yes. Sorry, can you give us the paragraph in the judgment?
Yes, I'm going to start at paragraph 80, which talks about permanent stays, and then I'm going to go on to temporary stays. So paragraph 80 addresses the suggestion of a permanent stay. The judge says that that would make no difference. It would be equivalent to setting it aside, just involve using a different form of word.
I mean, that's not quite right, is it? A permanent stay leaves in place a judgment that has a number of possible consequences.
Well, what the judge is saying is that it prevents enforcement of the judgment. It kills the effect of the judgment in terms of its enforceability.
Yeah, okay. It's not the whole story.
I see that. Well, that's why our preference is for setting aside. As I've said, but it's a distinction without very much difference in this case, at least. And then, if one goes then to paragraph 91 on page 87. He decides at 91 that whether the discretion should, under 3.17 should take into account the fact that the judgment is for damages to be assessed, in effect. And he records the parties' positions about what should happen to the security. And then the important point is at 93, at the top of 88, and then at 94 as well. 93 is the option of varying the judgment, which he decides is not appropriate. And then the critical point is this, is 94 on page 88. Mr. Sprague offered another variation on the same theme. He suggested I might only order a further stay of enforcement on an interim basis, pending clarity on the remanded issue. I agree that that course is theoretically open to me as a matter of discretion, as I consider whether to order that the English judgment be set aside. So just pausing there. Now, sure it is, because no one had referred to it, that the judge didn't say that that power existed under 40.8a, but it is precisely the discretion that he understood himself to have and considered
But he didn't have it under 31 points. Under 3.17.
I'm sorry, I
3.17
didn't.
is only concerned with setting aside.
Well, that was what the application was for, but
Exactly.
he's addressing a suggestion that there could be a stay of enforcement, and he had a discretion. He accepted he had that discretion. He doesn't say, I'm not doing that because it's not what the application is for. He does it because, as we go on to read, he decides there's no justification for doing it. And this is all, as we know, the only reason this has been suggested is because it's assumed that if the judgment is stayed and not set aside, then the security will remain in place.
But what he says is, I mean, ultimately his reasoning is, I shouldn't be deciding whether or not to set aside the English judgment with an eye to how the security might be preserved. So he thinks he's in a box where, essentially, he's exercising a jurisdiction under 3.17 or being asked for a permanent stay, which is functionally the same. And therefore, he's just got to decide whether he should or shouldn't do that. And he can't have an eye on the question of preserving the security. Now, if he'd been looking at it through the lens of 40.8a, he would have appreciated that he did have a discretion to deal with a temporary stay and to deal with the security in that context.
Well, yes, but he goes on to say that there is, in any case, no reason to treat the existence of the security as a reason to either withhold a stay, withhold revocation, or grant a stay.
Right, that's because he's faced with the binary choice of either acceding to or dismissing the application to set aside the judgment.
Well,
I quite understand that he thought if that's the binary question he has to answer, because it's a 3.17 question, I shouldn't be going into questions of a temporary stay and which raise questions of the security.
yes, well, it must be that he does accept that under, even applying 3.17, there's a discretion as to whether or not the judgment should be stayed on an interim basis. And
Where does he get that from? Sorry, where do you get that from?
well, from the way that he says.
No, sorry, where do you get that out of 3.17?
Well, the judge, there are a number of ways it could be done. He can simply refuse to set it aside and say it will remain stayed. He undoubtedly has that power. It's in terms of how one gives effect to it. That's probably the most straightforward reason. He could say, or he could adjourn the application and say, come back when you've got a US judgment.
I mean, the point that I think is being ignored in all this, really, is that there is a reason why you are entitled to enforce judgments at first instance, even if they're subject to appeal. It is a thing. It's a thing that has been recognised as a matter of law for many years, recognised in statute and understood and acted upon. And so the regime thereafter envisages that there will be enforcement, or there may be enforcement, pending, and requirements to put money up front, etc., as a quid pro quo or not enforcing. And so the fact that you've got a judgment and legitimately represented that judgment in an English order is quite significant. And you can't just say, because the judgment is appealed successfully but is going to be replaced, that you can treat it as non-existent. It's back to the nullity point. It isn't, the whole thing is not a nullity because we recognise that judgments that are obtained at first instance can be enforced. So there is always going to be the back and forth that we're having in this case, in some measure.
Well, if a creditor decides to enforce a judgment that's subject to appeal, then yes, that possibility exists, although there are...
That's what happened here.
It is what happened here. In my submission, a creditor who does that does so at its own risk, and if the judgment is set aside, then it can hardly complain if the English judgment then ends up being set aside itself. I accept it's not an automatic consequence, but it is...
well, that gives no weight at all to the principle of finality, which you say is important.
Well, I say it's not important in this particular context. In general, of course, it is important. It's the reason why the court doesn't likely go behind final judgments, final orders. But in this context, where the whole basis for the judgment is a debt that no longer exists as a result of the foreign appeal, as the judge said, the principle of finality carries little weight in that situation, and that's why the court
But he
is
was
justified
looking
in
at the whole thing
intervening.
through the wrong lens, as it appears now. He was looking at it through the provisions for interim relief, which
he was one, but all that did was cause him to take, if anything, too narrow a view of what could justify the court making an order.
I mean, he ought to have been looking at it, I would have said, through the lens of the section which provides expressly that the court may grant such relief on such terms as it thinks just, which is a different provision.
My Lord, I don't disagree with that so far as it goes, but I do say that it is absolutely clear from his judgment that what conclusion he would have reached if he'd been applying that alternative provision. It would have been exactly the same outcome and exactly the same analysis, except
well, I mean,
for the fact...
that's persuasive up to a point, but as you know, once you get your screwdriver, once they get their screwdriver into this judgment, we do what we want.
Completely accept that, my Lord, and I'm coming to that ultimate point of what ultimately the order should be. But if I may just say this, that the analysis and conclusions would have been exactly the same, except for the fact he would not have had to jump through the additional hoop, getting over finality and the restrictions that apply to CPR 3.17, because he could have just gone straight to the 40.8A. But
Have we got to your fourth point yet?
Well, I think that my fourth point was that the judge was aware that he did have a discretion. He did understand himself to have a discretion to grant an interim stay, and I quite accept my Lord Justice Popplewell's question as to on what basis, but undoubtedly he could have ordered an interim stay, either by way of declining to set aside the judgment or adjourning the application. And he would not have exercised that discretion. So, although he didn't approach it under CPR 40.8A, he did ask that question, should, as a matter of discretion, the judgment be left in place and stayed? And he said no. And the absence of any reference to 40.8A in my submission should not therefore lead to the conclusion that the judge misdirected himself in any relevant way, because he did in fact ask himself the relevant question. Well, the fifth point is...
Sorry to hold you up, but I slightly lost track of the chronology, but when Mr Justice Jacobs ordered the payment in of 25 million, that stage, the appeal had not yet been heard.
It had been heard.
Had been heard, but
decided.
not had the decision. So the potential at that stage was that the judgment might remain in place for the full 143 million.
Yes.
Or might be reduced. So the 25 million wasn't at that stage a pre-estimate of the maximum of the claim. On what basis did Mr Justice Jacobs think that it was appropriate to secure the judgment in part?
Well, he treated it as analogous to a case where there's a domestic appeal,
Yeah.
and it was a case of balancing the relative prejudice on each side, and also taking into account the evidence of Hytera's financial position. And he took the view, and the analysis is, without any disrespect, not very scientific, and not expressed to be scientific, but that was a sum which Hytera could reasonably afford to post without having to dismantle its business.
But without it being referable to any particular probability of that being the amount of enforcement, it was nevertheless generally there to provide for the eventuality that either all of or some part of the Illinois judgment would remain enforceable after the appeal.
Well,
presumably.
yes, and therefore the English. Well, no, that all of the English judgment would be enforced because, yes, that all of the English judgment.
Well, was it? I mean, that's what
would be enforceable.
And you say that, but do we need to look at the terms of his judgment? Because one can quite see that it might well be justified on the basis that we don't know what's going to happen in the Court of Appeal in the United States. We might be left with a judgment for 134 million. It might be a completely successful appeal, but for the time being, I think, as against the possibility of a judgment remaining in place for 164 million, it's right that 25 million should be available for enforcement, because that's what they can afford. If that's right, I'm not sure it follows what you were submitting earlier, that the security is only there because of the English judgment. I mean, procedurally, the English judgment is the peg on which it is there, but it's not the rationale for it.
Well, with respect, it is the rationale for it, and if it is the price of not enforcing the judgment, by which I mean the English judgment, which Motorola at that time had, and only that, and that must be right as a matter of principle, because there would have been no jurisdiction to order security absent that judgment. Just as security for some future judgment that might be obtained, including a future judgment following a remission and a new decision by the same court.
I follow that, but if one translates that to the current position, in which it's known that the maximum is 20 million, not 25 million, but leave that aside, there is an option to stay the 134 million judgment until the outcome of the US proceedings and then replace it immediately. Why isn't the rationale for putting the security in place equally applicable?
Because the rationale for the security was, and only was, that Motorola at that point had an enforceable judgment, and there was jurisdiction to stay enforcement of that judgment on terms that security was provided for it. There is otherwise no power to order security, and I mean the point is this.
I understand that point, but I'm distinguishing between power and rationale, because if, as a matter of power, under 40.8a, the position before Mr O'Sullivan KC was that it was open to him to impose a temporary stay on a basis which potentially included retaining that sum as security, a reduced sum. If he had that power, why couldn't he have applied the same rationale as applied when Mr Justice Jacobs was entering it, notwithstanding that Mr Justice Jacobs was doing it under a different.
Well, he could in terms of jurisdiction, because rightly or wrongly, the money was there, and he could make orders in relation to it.
Yeah, but he couldn't under 3.17, or at least he didn't think he could. And I didn't think he could.
Well, he thought he could with respect to
Sorry, vice versa. He thought he could, but I didn't see. Well, he thought. I think we have to be a little bit careful about what he thought, because although he was considering that as a possibility, his reason for not doing it seems to be tied to the fact that he's got to, as a matter of principle, apply 3.17 or not.
My lord, yes. Just to cut through this, if I can try and do that, the ultimate question is, as I say, what should happen to the security. I've made the submission that the judge exercised their discretion, and if he did that and was entitled to do that, then it's not a decision the court should interfere with, unless it was clearly wrong. But even if this court thought that the judge misdirected himself, and so it was appropriate to take the decision afresh, then in my submission it should make exactly the same decision in terms of the release of the security, because as for this reason, and I accept the court as a matter of jurisdiction could either release the security or not, but in terms of what is appropriate as a matter of discretion, the judge, with respect, was entirely right to order its release, because if Motorola turned up to court today with the facts as they are, then there would be no jurisdiction to order any security at all. His only option would be to apply for a freezing injunction, but it's already tried that and failed, and it can't, and that plainly wouldn't be available. Now, in our submission, it can't be in a better position just because it obtained a judgment based on the original US judgment, which we now know it was never actually entitled to, or it should never have had. And that is, if I could put it this way, it's the flip side of the principle that a first instance judgment is sufficiently final to be enforced. That is true, but the creditor who elects to enforce it proceeds at his own risk. If the judgment's overturned, the creditor should not be rewarded for having jumped the gun and allowed to keep the benefits of...
The creditor has not jumped the gun. The creditor had a perfectly enforceable judgment which it chose to try and enforce. And the point you're omitting, I think, is the words of 40.8a, which say, on such terms as it thinks just.
No, I'm not. With respect, well, I'm making the submission that it is just to allow the security.
But why would it not be just to the creditor to say, you plainly both don't like each other and litigate like mad, and when they had a judgment for 438 million, they managed to get some security for it pending the appeal, pending the decision of the appeal. And it's not just to give you that money back and make them fight again to get that money into court, because we know that in a matter of months, perhaps even weeks, there will be another judgment for some amount, and at that point you can apply and have it reduced if it's much less, or they can apply to enforce the rest if it's too small. But I mean, you're just assuming that we have to blow with the wind of the various events, which I don't see that that's the case. When the whole ethos of enforcing a judgment, even when it's subject to appeal, is that that is a relevant factor. It's a final judgment which you can enforce, and it may result in a little bit of injustice, and one side may get an advantage and the other side may not. But to say that we have to blow with every wind, would, a bit like the vacillation point I was making this morning, it's not particularly attractive. I mean, the judge has, Mr Justice Jacobs, in different circumstances, has ordered 25 million. Another judge has reduced that to 20 million. But there it is. We don't have evidence before us about whether 20 million was a good figure or a bad figure. We're not asked on this appeal to have we haven't got skeletons about the 14 million or 1.5 million. So why shouldn't we do a bit of sort of general basic justice and say this should stay here? We shouldn't send money backwards and forwards, and see what happens when the judgment comes out from America.
Well, only for this reason, Honourable Mr. It is, as we see it, a point of principle that a creditor who enforces a judgment that is then overturned should not be in a better position for a result of having enforced a judgment that it turned out it was not entitled to.
But if it's completely overturned, yes, obviously so. But I wonder whether your submission really focuses on form rather than substance. I mean, one might have a foreign court that was doing exactly the same thing as happened in this case, in which the Court of Appeal said the matter is remitted to the first instance court with power to vary its previous judgment so as to substitute another figure, and the effect of which would not be to revoke the first judgment, it would be to leave it in place until substituted by a lesser sum by the lower court. Now, it may not be what this court did what the US Appeal Court did in substance, but it's essentially doing the same thing. It's saying the judgment's got to be reduced, and there's going to be a reduced judgment in an amount which the first instance court is going to decide. It could do that in a way which formally left the judgment in place until it did that, or it could, as you say happened in this place, revoke it and leave it to be replaced. But it does strike me as odd that what this court can do now in giving effect to the rights that are either have been or are going to be recognised by the US court under a broad power to do what is just, is essentially bound by the form in which it took place rather than the substance of what took place.
Yeah, well, I hope I'm not being formalistic. It's a question of what is just, but I'm saying in that exercise, in that analysis, the point of principle does carry some weight. That in hindsight, it can be seen that enforcement was partially achieved on a basis which it shouldn't have been. There's also this point, which is the timing point, that when the US judgment in this case was set aside, that was 18 months ago, and that's when we applied for the release of the security and the setting aside. When the judge decided the application, that was almost a year ago, and at that point, any future judgment was a long way on. And so when one weighs in the scales the justice...
Not so the judge was told. The judge was told it was imminent.
Well, exactly.
Right.
In good faith.
Quite, although I'm not sure he proceeded on the basis it wasn't.
We now know it's been a long way off.
Exactly.
I mean, obviously, questions of timing might generally have a bearing on exercise of discretion, but
well, yes, they do, and they
not
should.
with hindsight.
And no, but we know it's been a significant amount of time, and the time of the judgment was, we now know, a significant amount of time. He didn't know how long it would be. He may have been told by Motorola it was imminent, but we didn't. That wasn't an agreed position. $20 million is a substantial sum of money. There are probably not many businesses for whom that would be an irrelevant sum of money in terms of them. It would be nice to be able to use it in one's business. For that to be tied up for a potentially lengthy period of time, in circumstances where it's now clear it should never have been tied up in the first place, is a very significant and prejudicial fact. So it's all very well with respect to say today, well, what's the harm in leaving things as they are? But that one can only be in that position because of the lengthy delays in hearing, first of all, the application and then the appeal. That's no criticism of anybody. But one has to ask, what's the right approach as a matter of principle, where there's a prospect that there'll be another foreign judgment, but after who knows how long, then it's, with respect, too simplistic to say, well, we are where we are now and let's just preserve the status quo. There should, in my submission, be a presumption, given the obvious prejudice in having $20 million that should never have had to be provided in the first place, tied up in court, that if the judgment is set aside, security should be, if the foreign judgment is set aside, then any security should be released until such time as there's a new judgment that can be informed.
If you're right that the judge considered this and on a sound basis, and he's exercised his discretion discretion and that we shouldn't interfere. I understand that. If, on the other hand, we were to take the view that the judge wasn't really considering how he would exercise the discretion under 40.8a because he was looking at it through the lens of 3.17, then in theory there were two potential routes. One is for this court to exercise the discretion afresh. The other is to send it back to be dealt with in the light of current indications about the extent to which the money is needed, what the arguments were in the hearing before the judge that's taken place, so that maybe a better idea of what the likelihood is and so on. But are you, in those circumstances, are you asking us to exercise our discretion? I think you were.
Well, I was on the assumption that the remission was not on the menu, as it were. But if that's something the court's considering, then I would say the more appropriate course would be to remit it, because obviously the judge some time ago has had some feel for the case, and crucially, we can guess, but the judge would know what decision he would have made under 40.8.
Well, I'm not sure it necessarily follows that it goes back to the same judge. It's just a question of whether we are as well placed to exercise the discretion on the basis that wasn't before this judge.
Well, yes,
Yeah,
I
you
need to
might-
take
you
instructions on that,
yeah.
if I may reflect on that briefly. May I discuss that with my...
Well, you may want more than a moment of turning your back. I think we just need to know before the case is finished what your
We'll take instructions and then
what your stance is on that.
by the end of the hearing we'll let the court know what our position is on that. That's all I was going to say on CPR 40.8. Now, as we discussed at the outset, there is the alternative or perhaps even primary case of enforceability. I wasn't proposing to say very much about that because realistically it does seem that that's not where we're going to end up.
They can enforce 135 million.
Exactly.
I'm not sure you need to say a great deal about that.
Unless I can assist further, those are my submissions.
Thank you very much. I don't know whether Mr. Rubin wants to do what you were doing. Mr. Strange is playing...
I'm not going to follow Mr. Milner on this one.
No. It wasn't that. It was just that you might want to make some general comments.
I have nothing to add.
No, thank you, Mr. Rubin. Mr. Strange.
No, it's just a few quick points. One, to give you some evidence, but also some submissions. So I respectfully disagree with the suggestion that if the judge was considering 3.17 and 40.8a at the same time, it would have been the same analysis and the same conclusion. And in terms of the practical realities of that, let's not forget what Hytera was asking for at the first instance hearing. They're asking for the order to be revoked and the money returned to them. And the only reason the money is still here is because the judge agreed to stay a lesser amount pending appeal here. So there would have been a very significant practical difference. If he'd revoked, leave aside appeal, the money would have gone, whereas if he'd stayed, the money would have stayed. And when, I don't think we've had a chance to look at his decision on keeping the 20 million, but there, I say, if the analysis he made there is applied to 40.8a, it's clear he would have kept the money and exercised.
Can you
You said the opposite.
Sorry,
Well,
I thought of paragraph 94.
No, I think the point here is about the permission to appeal application. In the permission to appeal application,
yes,
which resulted in the order, which is at page 311 of the supplemental 310, 309 of the supplemental bundle. He obviously gave a judgment about that, which is reflected in that order, but I haven't seen that judgment. Where is it?
Oh yes, my lord, that is in the Sullivan core bundle. It's his ruling, and it's at page 94, and it's tab 8.
Right, so that's the ruling which we looked at there.
Yes.
And while I'm thinking about it, I also haven't seen the ruling of Mr Justice Jacobs, which is reflected in the order which is in the supplemental bundle.
Yes, we're checking whether that's in the bundle. We've certainly got the paragraphs of his analysis of why he granted the stay, so I'll come to that in a moment.
Okay.
So here, so what happened is the judge gave his decision. If we could pick it up on page 95 of the core bundle, he gave the decision on 23rd January. He was persuaded to give permission to appeal. He notes why. And then in paragraph 3, Motorola applied for what is probably best described as a stay of execution in relation to my decision. And then 12, Motorola needs to identify solid grounds for a stay.
Paragraph 12.
That's page 97.
Yeah.
And then he neatly summarises the parties' submissions. And then paragraph 15 on that same page, you'll see what we say. It lists precisely what appeal targets, namely the retention. And then 16, Motorola points out that the US Court of Appeals has now affirmed the Illinois conclusion on liability for damages, and that questions of quantum have not yet finally been decided. And then 18, Motorola argues that there is a material risk that if the security is released but the appeal succeeds, the money will have been relocated to China and Hytera will not satisfy. And then 19, there's a reference to Mr. Justice Jacobs' decision. And then, if I can then take you please to page 99, you have Hytera's submissions. What they say there is that the stay would defeat the purpose of the substantive application. So by the substantive application, 317, they're trying to get the money back because there's no judgment and we're done. That's the, that was the point. And then 25, the payment was only ever intended to serve as a condition of the stay. It's not intended to function as security against future liability. And then 29, he summarises the essential plank. That's on page 100. And then, starting on top of page 101 is the discussion. Seems to me Motorola is right to say that the counterfactual with which I'm concerned, unless a stay is ordered. And then 35, once that is recognised, it does seem to me that on the basis of the material put before me, the balance approach is so one-sided as to mean that Motorola would suffer immutable harm if no stay is granted. Then 36, it seems to me more likely in the evidence I've seen that Motorola would face difficulties in enforcing the summary judgment in England. And then 38, I'm satisfied that these are solid grounds for granting a stay, and I accept that the loss of the security would amount to no more than a temporary inconvenience for Hytera. So that's the position in relation to...
More than.
Sorry, my apologies, Mr. Ribbon's right. So, and... Well, Lord, you posed a question. What is it exactly? You said there was 3 ways we could look at this in terms of through the judge's eyes. Did he just have 3173? Did he just have 40.88? Or both? And I say it's clearly both. That's the lens through which we must look at it. And there's a rhetorical question to be posed. And I need to show you some background documents to complete this. What would he have done if he had 40.88 available to him? We say it's very clear, both on what I've shown you, but also on the submissions that were made, that he would have stayed and he wouldn't have revoked. Now, on that, my lord, could I please ask you to take up first our first instance skeleton argument, which is in the supplemental bundle. And if you could go to page 214 of that, please. So this is our opposition to revocation. And we start out by saying, this is paragraph 20 on 214. We say there's a discretion, such as the provision by undertakings by the enforcement party to give credit for the sums in force, which has been offered. We then go through, and you'll see in 22.1, we refer there to Nuvian and Freeman and Moss and Martin. And then we apply those principles if you come to page 217 of the bundle, please, paragraph 24. So it can be taken briefly. There's no base for revocation of the summary judgment order. And one of the reasons we give, you see at 24.5, page 219 of the bundle. It's where we refer, you may recall that the judge described us describing CPR 3.17 as a blunt instrument. What we said there is there are several more attractive options, including permitting the enforcement with the undertakings. And then 2, a further interim stay of enforcement pending the issuance of the remanded decision, and then an adjournment of the application so the court can proceed on a more informed basis. And then if you go down to 26, precisely the same, as to the permit stay application, this would have precisely the same effect as the revocation application. The only justifiable stay would be an interim stay, which Motorola suggests could be achieved by an extension of the interim stay already granted by Fox and J in July 24 until early after the remanded decision. Just so you know, Mr Justice Foxon extended the Jacob J stay on the basis there's been a change in the payment terms. And then you'll see 27.3, the conditional sum application. That's where we said that the amount should stay. So that was that. And then I think you've seen our appeal skeleton insofar as we address this, but let me briefly remind you. So our skeleton is at tab 2 of the core bundle, O'Sullivan core bundle. And if I could ask you to go to paragraph 40. And in 40.1, the judgment accepts that a further interim stay pending the outcome of the remanded decision was a possible option, but wrongly tied that option on the risk of dissipation. We say a further interim stay was a simple case management option in light of the reality that would be a further remanded decision capable of enforcement. It was an option that would avoid the irremediable prejudice of Motorola losing potentially irreversibly the conditional sum. And I think you've already seen Mr. Barlow talk it to you earlier. If you go to page 35, it's paragraph 44 where we deal with audit Pereira. And 44.3 on page 36. And then we say there, rather than, as Motorola suggested, some form of stay. Now, I accept that we didn't say there 40.8. But the essence of an interim stay is certainly something that we say was there and argued. Now, the last point of substance is this. If you look at it practically now, and you're re-exercising the discretion, if the judge, sorry, you as the court, the facts that you've got now, if you imposed a stay under 40.8A with liberty to apply and the conditional sums remaining there, I say, and this court's probably not always equipped with a white book, but page 1286 of the white book in dealing with 40.88 refers directly to the list in 3.1 of general powers of management and says that insofar as they provide otherwise, they're covered by 40.8A. So it doesn't mean you would be excluding for all time the exercise of 317 if that became necessary. It would be, once we've had the remanded decision and the parties have read it and come to conclusions about the consequences if there's no consent order, we would be before a court with an interim stay coming to an end and the parties seeking whatever relief they considered appropriate with a broad range of possibilities, because that's why the genesis of the stay would be under 40.8a. So for those reasons, I say it's taken a long time and hasn't been done perfectly, but it's obvious that 40.8a is the route to take. And besides all of the practicalities and appropriateness that I've described, the single most important difference is that you would not have to run into the dead weight of finality. Because the huge distinction between 40.8a and 3.17 is you don't have to deal with finality. In other words, you don't have to weigh up finality against anything else. You might eventually, but maybe not, who knows. So we say that's a much more preferred course, both on the practical side, but also as a matter of principle. So, my Lord, subject 20. Yes, just one thing. Mr. Bala tells me that Raja is no help to you because the facts of that case would
He says
Raja is not a case that assists you with respect to these considerations. I'm not sure I've done justice to his note, but there we are.
I've got one. He's not sure either.
No, I'm not quite sure, my Lord. But
I've got one question for
Yes.
you, which is that the other case is that of Michael Wilson Partners,
Yes.
Which is a case referred to in the note
Yes.
in the White Book,
Yes.
and is a decision ex tempore of Mrs. Justice Whipple, as she then was,
Yes.
where she casts doubt, well, basically says that probably what Mr. Rubin or Mr. Milner would be pleased to hear, is she casts doubt on the interchangeability and says these are two, you can use either 3.17 or 40.8a, but it says at the top in the Westlaw version, negative judicial consideration, and I have not been able to find that negative judicial consideration. So after we reserve judgment, I am going to ask that your juniors very kindly find, if they can, the negative judicial consideration of the Michael Wilson case, just in case it casts any doubt, any light on anything we've heard, and if you think it does cast light and you wish to make half a page of submissions, you may do so by Friday afternoon.
Thank you, my Lord. So I now have nothing further to say, and thank you very much, Your Lordships, for your patience, and obviously wish Lord Justice Phillips a speedy recovery.
Can I ask one thing?
Oh, sorry, Mark.
Which is what I also asked Mr. Milner. If we were to take the view that because of the way the matter was argued under 3.17 before the judge, he did not exercise his own discretion on a proper basis as to whether to retain the security and grant a temporary stay, do you say that that is then a matter that we should ourselves address and exercise our own discretion, or do you say that we should set aside the order that he made, hold the ring for the time being in relation to the security, and remit the question as to whether a temporary stay should or should not include the retention of the security?
Remit, my Lord, to first instance, depending on the outcome of the remand.
Well, it wouldn't necessarily be depend on the outcome of the remand. It might be remit to decide now.
Right.
Whilst it may be as a matter of timing, it couldn't be done
Yes.
soon enough, but it would be for the discretion to be exercised afresh, it not having been exercised on a proper basis in the first instance.
Yes, and subject to being told otherwise, my lord. My position. Unsurprisingly, it's consistent with what I was going to say. My attitude towards these things is if the Court of Appeal wishes to remit something to first instance, then they should. If they feel that it's something that they should keep to themselves and exercise the discretion, they should. In other words...
You're neutral on the question.
I'm neutral on the question.
All right.
I know what answer I want, my lord. Neutral on forum.
But you're neutral as to who you get it from.
Quite, my lord.
We know what answer you want to. Good, is that?
That is it, my lord. Thank you very much.
Well, thank you all.
And has Mr. Milner had an opportunity to take instructions?
I'm afraid not, my lord, because we think we need to get instructions from our client, which is in China. So if we may, if our position is anything other than neutrality, then is it all right if we...
Please get us the answer by 4 p.m. on Friday.
Understood.
Thank you. We will take time to consider our judgments. We hope that there are not conflicting judgments, otherwise the illness of Lord Justice Phillips will be very awkward. But we'll deal with that when the time comes. When we hand down our judgments, will you please make sure that you only use them for the purpose of agreeing an order as to costs and agreeing an order, and for no other purpose whatever. That is particularly important in this case because it's no doubt politically and market sensitive. It is therefore likely that we will give you very little time for corrections. My normal practice is to hand down, giving you a day for corrections, having warned you when it's coming so that you have somebody available to do the corrections, and then giving you a further week to spend your time agreeing the order and costs after the hand down, so that we don't have draft judgments lingering around, which could fall into hands where they should not go. So that's probably what we'll do, but thank you not only to leading counsel but also to junior counsel for their close attention to the detail of the case, which has been interesting and possibly significant for the reasons we identified today. Thank you.